There are two hidden clauses in your car purchase agreement the dealer probably doesn't want you to pay attention to. Now, when people go buy a car from a dealer, they're very interested in basic stuff, the price of the car, any credit for a trade-in, interest rate, taxes, fees, and all of that. But you need to consider two other important parts in the contract that talk about what happens if something should go wrong down the road. And the first one is an arbitration agreement. Now, if you go through the fine print or possibly even bold print in the contract, there's usually something titled arbitration, and it's going to say that the disputes related to the purchase have to be arbitrated, or maybe it'll say either party can choose to arbitrate. The dealer will definitely choose to arbitrate. And so what this means is you're just giving up your right to trial by jury, and that's important for the dealership because juries tend to not favor big corporations versus a single person who's bringing a lawsuit. However, in arbitration, the corporations get a much fairer shake, so it saves them a lot of money. So your contract probably has an arbitration agreement in it. You might ask the dealer, hey, I don't want arbitration. I don't want to give up my right to a trial by jury. And they'll probably tell you no. If you don't want to sign this, you're going to not get the car. So there might not be anything you can do about it, but it's certainly worth a try. Now, the second important thing that is in the contract, should there be a dispute, is the choice of law. And what that means is if you look somewhere else in the contract, it's probably going to tell you that if there's a dispute, a certain state's law is going to apply. And that might be the law where you're buying the car. I'm here in Las Vegas, so if I bought a car here, the contract would probably say that Nevada law applies. Sometimes it's a little different. Sometimes it might be where the headquarters of the corporation is. So it might not even be the state where you're in. So obviously, if there's a dispute later and you need to bring a claim and you live here in Nevada, but it says the choice of law is Texas, well, that's a giant pain to go to Texas to litigate in Texas, and you might not even know what Texas law is. It's probably a lot more favorable to the dealership than it is to you. So if you're buying a car in state A, but it says the law of state B applies, you might also ask to change that to the state you're in. Are they going to do it or not? Oh, they're probably not going to do it, but at least you should try, and at least you should be aware that this could potentially be an issue down the road. Now, kind of unrelated, but what happens a lot of times is people, for example, who live in California will buy a car there, and then they'll move to Nevada, and then something happens. Well, they'll look in their contract, and they'll say, oh, look, California law applies. So that means the claim needs to probably be brought in California, and if nothing else, California law would apply to the dispute, and California law a lot of times is different than Nevada law. So pay attention to these two things when you buy a new car or a used car. You just have to buy the car from a dealer, read through your paperwork, and if you've ever been burned by a dealer based on something in the paperwork about arbitration or choice of law, drop a comment below.